This is Hidden Killers with Tony Bruschi. Here now, Tony Bruschi.
On February 11th, not far away, Alec Murdaugh will sit in front of 5 justices at a South Carolina Supreme Court, or at the South Carolina Supreme Court. There is one. This is the big one, is where he is going to be at. Well, his attorneys make one final argument. And the trial that put him away for life, it may be washed away. Because they're going to be arguing that that very trial was fundamentally broken. And here's the thing. They may have a point. Not because Murdaugh is innocent. The evidence against him is substantial. His character itself is monstrous. The evidence against him, it is what it is. Because the woman who read his guilty verdict out loud in that courtroom, the clerk of court, who is supposed to be a neutral guardian of the process, well, she's since pled guilty to perjury. She admitted to lying under oath at the very hearing that was supposed to determine whether Murdaugh got a fair trial, and somehow that's still not enough to automatically get him a new one. People really don't like Alec Murdaugh, and rightfully so. But we do have to play by the rules, children. And if the rules were broken and one of the people who really never should have been a referee but basically kind of inserted herself as being one affected the players, meaning the jury, one of the players even said, yes, her opinion affected my opinion, then you didn't have a fair trial. No matter how icky Alec Murdaugh is, it is what it is. Oh, the evidence would get him anyhow. Yeah, you're probably right. But what if this wasn't Alec Murdaugh? What if it was somebody who actually genuinely was innocent? And you had this sort of behavior going on. We've seen it in other cases. And it's horrifying. This can't be allowed to happen. This can't be normalized. This can't be, well, he's icky enough anyhow, so go on with your big, bad, inappropriate self at the courtroom. No, I mean, they found it so bad, they convicted her. So let's break down what's actually happening on February 11th. What the defense is arguing, what the state is arguing, and what it all means, not just for Alec Murdaugh, but for the integrity of a system that's supposed to work the same way, whether you're a disgraced attorney from a powerful family or anybody else. And while we do that, give me your thoughts in the comment section on YouTube or on our Substack. It's absolutely free to join right now. And you can get all of our videos, all of our reporting a day before everybody else, and with no commercials. And the forum right there, you can comment on directly to the studio. Be part of our community on Substack. I'm asking you to please join us right now over there. The link is in the description. It's hiddenkillers.substack.com. All right, let me take you back to where all this started. Way back. June 7th, rather, of 2021, Maggie Murdaugh and her 22-year-old son, Paul, are found shot to death at the family's hunting property in rural Colleton County. Alec Murdaugh, the family patriarch, says he called 911 just after 10 p.m., says he came home and found their bodies near the dog kennels. He tells investigators he hadn't been to the kennels that night, stayed at the house, took a nap, went to visit his ailing mother, came back to a nightmare for months. That was his story. He told it to investigators, he told it to family, he told it to friends, and then in April of 2022, a forensic team cracked the passcode on Paul's iPhone, his birthday, by the way, nothing complicated, and they found a 50-second video that kind of changed things up a little bit. Paul had recorded a clip at 8:44 p.m. that night, trying to capture footage of a friend's dog in the kennel. The video shows his hand, the dog, nothing remarkable, but in the background you can hear 3 distinct voices: Paul, Maggie, and Alec, talking about their yellow lab, Bubba, who apparently had a chicken in his mouth. The video put Alec Murdaugh at the murder scene approximately 4 minutes before prosecutors say the killings happened. It shredded his alibi completely, and when confronted with it at trial, Murdaugh finally admitted he'd been there, but claimed he lied because of paranoid thinking from his opioid addiction. The jury did not buy it. And on March 2nd, 2023, after less than 3 hours of deliberation, they came back with guilty verdicts on all counts. Judge Clifton Newman sentenced Murdaugh to 2 consecutive life sentences without the possibility of parole, and that should have been the end of it. But 6 months later, Murdaugh's attorneys, Dick Putalin and Jim Griffin, dropped that bombshell. They had affidavits from jurors. They had evidence. They claimed that the Colleton County Clerk of Court, a woman named Becky Hill, had tampered with the jury, that she'd told jurors not to be fooled by Murdaugh's testimony, that she'd urged them to watch his body language when he took the stand, that she'd pressured them to reach a quick verdict, and that she'd done all of this because she wanted a guilty verdict to boost sales of a book she was planning to write about the trial. The book, by the way, came out 4 months after the verdict. Behind the Doors of Justice, The Murdaugh Murders. Hill was the co-author, and according to the defense, she had a financial motive to make sure Murdaugh went down. In January of 24, retired Chief Justice Jean Toll held an evidentiary hearing. She questioned all 12 jurors personally. She grilled Becky Hill on the stand, and at the end of a day-long proceeding, she issued her ruling. Toll said Hill was not completely credible as a witness. She said Hill had been attracted by the siren call of celebrity. Oh, the siren call. Because she's from 1848. She found that Hill had, in fact, made comments to jurors about Murdaugh's demeanor before he testified. But here's where it gets complicated, because apparently that siren call wasn't loud enough. She also said those comments weren't enough to warrant a new trial. I know, when you're using terms like siren call of celebrity, it kind of sounds dramatic. Maybe use like different terminology if you're going to like build it up and then like, sorry, it means nothing. So like, yeah, she said some shit, but it doesn't matter. That seems more like kind of the outcome. She said some shit, but it didn't matter. Not the siren call of celebrity basks in the sunlight and the moon rays as the ocean tides beckon to its demands. And I made that up as I went. But again, the siren call wasn't enough. Not enough to warrant a new trial, according to Jean Toll, who's having breakfast with the Crypt Keeper this morning. 11 of the 12 jurors said Hill's remarks had no effect on their verdict. But one juror, identified as Juror Z, said she felt influenced. But she also stood by an affidavit saying she felt pressured by other jurors, not Hill, too. So there's that. Toll called Hill's comments fleeting and foolish, and said she couldn't overturn a 6-week trial based on them. The motion for the new trial was denied by Jean Toll, and she knew that it wasn't the end of the story. She just knew that she wasn't going to be the one that gave Alec Murdaugh a new trial. Right or wrong, he wasn't going to be on her watch. Someone else can answer that siren call. Murdaugh's team appealed, and now nearly 2 years later, the South Carolina Supreme Court is finally going to hear oral arguments. But here's what's changed since Toll's ruling. Becky Hill's story got a lot worse. She resigned from her position as clerk in March of 24, citing public scrutiny. In May of 25, she was arrested and charged with felony misconduct in office and perjury. And on December 8th of 25, just 2 months ago, she stood at a Calhoun County courtroom and pled guilty to 4 criminal charges. Obstruction of justice for showing sealed crime scene photos from the murder trial to members of the press. Here, guys, find me valuable. Make me feel special. I'm going to show you some pictures. She's like the little asshole kid in the playground when you're a child. I have this really juicy note I'm going to show everybody. It's going to ruin somebody's reputation, but you're going to think I'm really special because I have access to this note. You want to see? I'm writing a book. I'm writing a book in my free time in study hall. You want to pre-order? I take Venmo. Perjury for lying about it. When Toll asked her directly during the January 24 hearing, 2 counts of misconduct in office and for taking $11,000 in improper bonuses and for using her public position to promote her book. She certainly found ways of taking advantage of her situation. The judge gave her 3 years probation and 100 hours of community service. No jail time. And he made a point of saying the sentence would have been very different if investigators had found evidence that she actually tampered with the jury, even though they kind of did. But here's the part that matters for Murdaugh's appeal. The perjury charge, the one Hill pled guilty to, arose from her testimony at the Toll hearing. The very hearing that was supposed to determine whether Murdaugh got a fair trial. When Toll asked her, "Did you ever allow anyone from the press to view the sealed exhibits?" Hill answered, "No, ma'am." That answer was a lie. She knew it was a lie, and she said it under oath. Now, to be clear, Hill's perjury conviction was specifically about lying regarding the sealed exhibits, not about her statements on jury contact. She was never charged with jury tampering. Investigators said 11 of 14 jurors and alternates didn't corroborate the tampering claims, but the defense argues that if she lied about one thing under oath at the hearing, her denials about everything else really can't be trusted either. And you have a juror saying that she influenced them. That's the argument they're bringing to the Supreme Court. Murdaugh's attorneys filed a motion on January 9th asking the Supreme Court to add Hill's guilty plea documents to the appeal record. Their argument is very straightforward. If Hill perjured herself at the hearing that denied Murdaugh a new trial, how can the court rely on anything she said that day? And if her credibility is destroyed, shouldn't the sworn testimony of the jurors who said she tried to influence them carry more weight? Harpootlian put it bluntly, if Becky admitted perjuring herself in the jury tampering hearing held by Judge Toll, what else could she have lied about? That's the first major issue the Supreme Court will consider. But it's not the only one. The second track of Murdaugh's appeal challenges what happened inside the courtroom during the trial itself, specifically Judge Newman's decision to allow extensive testimony about Murdaugh's financial crimes. The prosecution's theory was that they called the gathering storm. By June of 21, Murdaugh was boxed in. He'd been stealing from clients and his law firm for years, over $12 million, as it turned out. A hearing in a wrongful death case was scheduled for June 10th, just 3 days after the murders. That hearing threatened to expose his bank accounts and reveal the extent of his theft. Prosecutors argued Murdaugh killed Maggie and Paul to generate sympathy, delay the investigation, and buy himself some more time. To make that case, the state put on nearly 2 weeks of testimony about Murdaugh's financial crimes he hadn't even been tried for yet at that point. Witnesses testified about clients he'd defrauded, families he'd stolen from, settlements he'd diverted into his own accounts. The jury heard in exhaustive detail about how Murdaugh had victimized some of the most vulnerable people who came to him for help. The defense objected. They argued it was prejudicial. They said the jury was being turned against Murdaugh not because of evidence linking him to the murders, but because they were being shown over and over that he was a terrible person. They called it a trial within a trial, character assassination disguised as motive. And Judge Newman, he disagreed. He ruled the financial evidence was admissible under multiple legal theories and said the jury was entitled to hear the complete narrative. Now the defense is asking the Supreme Court to overturn that ruling. In their final brief filed in November, Murdaugh's attorneys wrote that the prosecution's motive theory defies logic and human experience. They called the gathering storm narrative storytelling masquerading as motive, and they argued that the trial was fundamentally compromised from the beginning. They also raised issues with the investigation itself. They claimed SLED agents trampled the crime scene. That first responders destroyed potential evidence, including bloody footprints. That fingerprints were never lifted from the feed room doors where Paul was killed. The tire tracks in wet grass, tracks that didn't match any Murdaugh vehicle, were never followed. That DNA from an unknown male found under Maggie's fingernail was never submitted to the national database for comparison. The state's response? The evidence is overwhelming. The jury convicted Murdaugh because he was obviously guilty. Even if there were errors, they were harmless. The financial crimes testimony was properly admitted and corroborated by documents, bank records, and Murdaugh's own admissions on the stand. And as for the investigation, prosecutors say the defense is simply relitigating issues that were already addressed at trial. So, where does that leave us? Well, on February 11th, the justices will hear oral arguments on both tracks, the jury tampering allegations and the underlying trial errors. The hearing starts at 9:30 a.m. It'll be open to the public on a first-come, first-served basis and live streamed. We will be carrying it here. What the court decides could come down to a single legal question. What's the standard for proving jury tampering? Murdaugh's attorneys argue for the federal standard. Under that framework, if a court officer attempts to influence a jury, prejudice is presumed. The state doesn't have to prove the tampering charge or change anyone's vote. The mere attempt is enough to taint the verdict. Toll applied which she believed was the South Carolina standard. She required the defense to prove that Hill's comments actually changed a juror's mind. And since only one juror said she was influenced, that juror also cited pressure from fellow jurors. Toll found the burden wasn't met. If the Supreme Court adopts the federal standard, Murdaugh's path to a new trial gets a lot shorter. If they uphold Toll's approach, the conviction probably stands. And here's the part that gets lost in all of this. Even if Murdaugh wins, even if the Supreme Court throws out his murder conviction and orders a new trial, even if he's somehow acquitted at that trial, he's never getting out. Murdaugh already pled guilty to stealing $12 million from his clients. He's serving 27 years on state charges for that. He's got federal time stacked on top of it, consecutive sentences. He waived his right to appeal those convictions as part of his plea deal. So this isn't about Alec Murdaugh walking free. That's not happening. The man is going to die in prison either way. Which raises the question, why fight? Harpootlian says it's about the integrity of the system, fair trials in South Carolina, as he put it, and there's something to that, because whatever you think Alec Murdaugh did or didn't do, the process matters. The rules matter. And whether the person responsible for managing a jury turns out to be a convicted liar with a book deal, it's worth asking whether the process was clean. So here we are. The clerk who read the guilty verdict has since pled guilty to perjury. The hearing that was supposed to investigate jury tampering relied on testimony she now admits was false, at least on the question of sealed exhibits. Investigators say they couldn't prove she actually tampered with the jury, but they also say 11 jurors didn't corroborate the claims, which isn't the same as saying it didn't happen. It means they couldn't prove it happened. And the man at the center of all this sits in state prison, serving 2 life sentences for murdering his wife and son, while his attorneys argue that the trial that put him there was broken from the start. February 11th won't give us a final answer. The justices will hear arguments, ask questions, and then take the case under advisement. A decision could come in weeks. It could come in months, and if Murdaugh loses, his team has already signaled they'll take it to federal court, a process that could drag on for years. But whatever happens next, one thing is already clear. This case stopped being just about Alec Murdaugh a long time ago. It's about what happens when the people running the system decide they want to be part of the story. It's about a clerk who saw a celebrity, the siren call, and reached for it. A trial that became a spectacle, and a question that should be simple, but somehow isn't. Did the defendant get a fair trial? Becky Hill admitted she lied under oath at the hearing meant to answer that question. Whether that lie was about jury tampering or sealed photos, she looked a judge in the eye and told her something that wasn't true. And the system's response so far has been to give her a probation and move on. Whether that changes now is up to 5 justices in Columbia. As always, Alec Murdaugh maintains his innocence on the murder charges and stands convicted pending any appeal outcome. Becky Hill pled guilty to obstruction, perjury, and misconduct in office. She was never charged with jury tampering. What do you think in the comment section? Tell me on YouTube. Let's continue this conversation off the air. February 11th ain't far off. Give me your thoughts in the comment section. I would love to hear them. You can also join us on our Substack. It's free right now. There's no paywall, and you get our reporting a day in advance. So you get our videos a day before they go up everywhere else, or audio, whatever you want. It's there, and it's ad-free. Check it out. Join us. Get access to the extras right now in advance. I do definitely appreciate that. And if you're on Apple Podcasts, hey, leave us a review there. Greatly appreciate that. Helps us in the rankings. Lets other folks know that you are finding our reporting valuable, and then lets them know about it. So if you got a few moments, if you're finding this valuable, please do leave that review on Apple Podcasts. Until next time, I'll see you in the comments for the conversation. I'm Tony Bruschi. We'll talk again real soon.
Want more on this case and others? Then press subscribe now and don't miss a moment of true crime coverage from Tony Bruschi and the Hidden Killers podcast.